What relief can a Texas court provide in a non-compete lawsuit? I'm Zach Wolf. I'm a Texas trial lawyer, and in this video I'm going to cover the 6 major remedies that may be available in a lawsuit to enforce a non-compete in Texas. The first one is a TRO. Marker, please. Thank you. A TRO is a temporary restraining order. This is an emergency order that a judge issues, and in this case it would be to enforce the non-compete by ordering the employee not to work for a competitor. The special thing about a TRO is that it can be entered on an ex parte basis. Ex parte just means where the judge hears from one side of the case without hearing anything from the other side. That makes it unusual. So in most cases, judges are going to be a little reluctant to sign a TRO to enforce a non-compete unless there are some special circumstances. For example, if there are allegations that the employee has taken off with trade secrets or the company's confidential information. The TRO in Texas state court is usually not going to last more than a couple weeks, and then there's going to be a temporary injunction hearing. At the temporary injunction hearing, the judge is going to hear evidence from both sides. So it's going to be kind of like a mini trial of the non-compete case. After hearing the evidence, the judge will decide whether to enter a temporary injunction to bar the employee from working for the competitor. Now, the thing to understand about a temporary injunction is that it's going to last from the point of the temporary injunction hearing all the way until the time of the trial in the case. And that can be a long time. So then when you get to the trial, the judge is going to decide whether to enter a permanent injunction to enforce the non-compete. Now here's the practical thing about injunctions in non-compete cases. If you've watched episode 1 of my videos, you know that a non-compete has to be reasonably limited in time period. A typical reasonable time period would be 1 or 2 years. That's also about the same amount of time it typically takes for a non-compete lawsuit to go to trial. So as a practical matter, a temporary injunction enforcing a non-compete can be, in effect, the same as a permanent injunction, because by the time you get to trial, often the time period of a reasonable non-compete will either expire or be close to expiring. The fourth thing that a judge can award in Texas in a non-compete lawsuit is something called reformation. That's kind of a fancy legal term, but all it really means is that the judge rewrites the non-compete to the extent necessary to make it reasonable. Different states have different rules about reformation. Texas is very pro-reformation. The Texas non-compete statute says that the trial court judge shall reform a non-compete if the non-compete is unreasonably broad. So reformation is another important remedy, especially in non-compete cases. Now, the next remedy that may be available is damages. In a non-compete lawsuit, the damages would usually be the lost profits that resulted from the employee leaving one company and going to another. In most cases, you're going to be talking about sales to customers the employee took with him or her when going to the new company. Now, an important thing about damages in non-compete cases is this. If the non-compete is unreasonably broad, as I said before, the judge can reform it to make it reasonable. But in that case, the company is not going to be able to get damages that occurred before reformation. So as a practical matter, that means if you're the employer and your non-compete is too broad, you're not going to get damages. You're going to be limited to getting an injunction and reformation. So that's very important. The final thing to be aware of in non-compete cases is the availability of attorney's fees as a remedy. In Texas, you typically can get attorney's fees in a breach of contract lawsuit. If you're suing to enforce a contract on a breach of contract theory, there's a statute that generally allows you to recover attorney's fees. But that's not the case in a non-compete lawsuit. That's because Texas courts have interpreted the remedies that are listed in the Texas non-compete statute as exclusive. And so Texas courts have said that the employer cannot get attorney's fees for suing to enforce the non-compete. So those are the major remedies that are available in a Texas lawsuit to enforce a non-compete. Thanks for joining us.